Hello and welcome to IFAQ's presentation, aimed to bring all of you awareness of the new EU General Data Protection Regulation, otherwise known as GDPR. This is a new regulation that will come into effect on the 25th of May 2018, and it will apply to all firms involved as either controllers or processors of client data. It will bring a considerable amount of work to bring you to compliance, but this is where IFAQ will come in, assisting and guiding firms to compliance on time. Today, I shall explain the main aspects of the GDPR you need to be aware of, and I will highlight the changes to current UK data protection laws, and I'll go over the effect this will have on firms. I will also be discussing the package that IFAQ is offering to support firms in their preparations for becoming GDPR compliant. First of all then, let's have a look at what the GDPR actually is. The GDPR is an EU initiative which, as I said, will automatically become law on the 25th of May 2018, replacing the UK Data Protection Act of 1998. It will unify data protection regulations across EU member states, and interpretation by individual countries will no longer be allowed. Essentially, the GDPR is a new set of regulations governing firms' storage, security, and use of personal data, and it also covers how this data should be protected. It's really been brought in to reflect changes in technology and the way in which organisations collect information about people, and it provides a more detailed and broader definition of personal data in the modern technological age. For example, an online identifier, such as an IP address, is now classed as personal data. The main aim of the GDPR is to promote individuals' rights surrounding their personal data and increase firms' level of accountability. This is where IFAQ will assist firms, both in terms of becoming compliant, but also having the paper trail in place to prove your compliance. It's worth remembering that the UK isn't scheduled to leave the EU until March 2019. This is almost a year after the GDPR comes into effect, so you won't be able to rely on Brexit for not implementing the GDPR into your business. And furthermore, there's currently no indication that the UK would look to rewrite the GDPR after its EU exit anyway, so the expectation must be that the GDPR will be around for the foreseeable future. Turning now to the main elements of the GDPR. The GDPR is articulated in 99 articles contained within 11 chapters of the regulation. Thankfully, not all of these 99 articles will be relevant to every single firm, and we'll just be discussing a few of them today. The main elements for consideration, and the ones most likely to affect you, are displayed in the diagram. I will talk through each of these in turn, highlighting any changes to current UK data protection laws and the changes firms will need to implement. Starting off with accountability and governance. This is really an overarching principle of the GDPR, and in essence, it means that firms must be able to demonstrate that privacy of personal data is both an integral and a routine part of their way of working. We suggest that firms appoint an individual or a committee to be responsible for taking the firm to compliance. This person or persons will ensure that staff have been made aware, that there's a record of it, that data is modernised and cleansed, that systems are updated for compliance, that an audit trail is in place, and that data is easily accessible. Another part of the firm being accountable under GDPR is being able to evidence that the risk of data breaches has been assessed, and that the firm have taken steps to mitigate such risk to reduce the likelihood and depth of harm to individuals. Turning now to the further 6 subheadings, which are all constituents of a firm's accountability with regards to its GDPR commitments. Okay, so the first subheading is strengthened individuals' rights. This is really cemented as the foundation of GDPR. It's one of the reasons the EU wrote the GDPR. It includes several rights for individuals, which I'll list now. Firstly, the right to be informed. Secondly, the right of access. Also, the right to rectification, the right to request erasure, the right to restrict processing, the right to data portability, the right to object, and finally, the right not to be subject to automated decision-making, including profiling. Okay, so that's quite a few rights for individuals which have been brought out under the GDPR. What it means in practice is that it is a firm's responsibility to ensure that individuals receive clear and concise information in language which is easy to understand. It's imperative that clients understand what personal data of theirs is being stored, why the firm needs it, and what the firm is doing with it. It should be abundantly clear to the client why they have to share that data with the firm and what the firm's lawful basis is for processing that data. It's worth just noting for a minute, I mentioned the right to request erasure. This isn't actually the same as the right to automatic erasure. Where there's a legal basis to keep the client's data, which is not necessarily based on consent, then the firm wouldn't have to fulfill a client's request to delete their data. This will all be documented though as part of the audit process that I'll come on to shortly. Another important change under the GDPR and another strengthened individual right is that a firm will no longer have permission to charge a client to access their data. So the £10 fee, which you can currently charge if a client asks to see their data, this will be scrapped, and from the 25th of May, you will have to provide the client with their data free of charge. And in addition, instead of the current 40 days, the time frame for providing a client with a copy of their data will be reduced down to 1 month. Okay, moving now on to the personal data inventory. This is a main aspect of the GDPR, and it's the first stage that those responsible within firms will be concerned with. It will require firms to report and evidence what personal data they are processing, the reason behind this, and the lawful basis supporting it. IFAC have created a dedicated microsite which contains a pre-prepared personal data inventory, which you can upload your client data onto, and it will help you in the record process. It's a very easy process to upload the client data. There's tick boxes and checklists, and it'll be extremely easy for you to check all of your data is GDPR compliant. Firms must also report where personal data is being stored, either on paper or electronically, and if any suppliers or third parties are processing data on their behalf. Again, IFAC are here to help throughout this process. Firms may also need to organise an information audit and will need to cleanse their existing data. This should be done as soon as possible, especially if you have a large amount of personal data that you process, to ensure that you don't miss the May 2018 deadline of becoming compliant. Ideally, of course, you should finish the personal data inventory stage, uploading all your data onto our microsite, while in advance of the deadline, so that IFAC can then audit that inventory and you can have the paper trail in place in advance of the deadline. But IFAC will work with you to find a workable solution where this may present difficulties. Just jumping back to the last point on strengthened individuals' rights. A reliable personal data inventory is crucial because it will make it much easier for you to understand which of your data requires consent and which has another legal basis for holding it, and therefore if an individual requests for their data to be erased, it will make it much easier for you to see whether you need to meet that request or whether actually you have another lawful basis for holding on to it, and therefore you don't need to delete their data if you're asked to do so. Okay, so moving now on to consent. As I mentioned already, an individual's consent isn't always necessary to process their data, but in cases where you are relying on consent, it's essential that this is freely given in a manner which is specific, informed, and unambiguous. It must be on an opt-in rather than opt-out basis, and silence, inactivity, or pre-ticked boxes will no longer be regarded as an acceptable form of consent. Personal data that has been obtained without this new, tighter form of consent will either need to be deleted or new consent will need to be sought before the May deadline. All of this will be recorded in the personal data inventory, which will prove vital in deciding which data requires an individual's consent and which does not. Again, as I mentioned before, the personal data inventory is all pre-prepared for you on IFAQ's microsite, so as soon as you sign up to the package, we'll be ready to go with creating you a login for that. Okay, moving now on to suppliers or third-party data processors. For a firm to be GDPR compliant, it must not only be aware of the personal data it itself is processing, but it must also be aware of any third parties who are processing or are joint controllers in respect of its personal data. Under the GDPR, the firm is still accountable for the actions of third-party data processors. However, the data processor will also now have additional legal obligations. This is where firms will need to go through and review existing contracts and ensure that, if necessary, new contracts are drawn up between the firm and data processor. IFAQ will be providing firms with a checklist for third-party agreements and will also be available for individual inquiries where firms are not clear, and these will also be audited as part of the compliance process that IFAQ recommends to you. Okay, moving now on to privacy notices. Anyone who's ever read or just attempted to read a full-length privacy policy will probably be aware that they are often long and complicated documents that are difficult to fully understand. Indeed, it's been estimated that it would take over 200 hours for an average person to read every privacy policy for every website they visit in a year. The GDPR tackles this impractical approach to privacy policies, and whilst full-length privacy policies may remain much the same, users must initially be made aware of the salient facts in an easy-to-read notice at the point of consent or data collection. This simplified privacy notice must be written in clear and plain language, be provided free of charge, and it should address the following key questions. What information is being collected and by whom? How is it collected and how will it be used? Why is it being collected and on what legal basis? Who will it be shared with? And finally, what will be the effect of this on the individuals concerned? Whilst this simplified notice should be as concise and as transparent as possible, individuals should still be directed to the full privacy notice to read if they wish to do so. IFAQ will be assisting firms with modified privacy policies. We'll be providing you with a template privacy policy, and we can also check your own ones over, but this will happen once the inventory process is complete. So once you've uploaded all of your data onto the personal data inventory on our microsite. Okay, thinking now about data security and breach notification. Of course, in the ideal world, a breach won't occur, but firms must of course be prepared for the worst case scenario under GDPR and must be able to act accordingly if the worst did happen. This means that firms will need to put policies and procedures in place to manage any data breaches. In addition, all firms, whatever their size, will have a duty to check, investigate, and report certain types of data breach to the ICO within 72 hours. This also includes when a third party or supplier has breached data protection. So that's why it's so important on the personal data inventory to be extremely clear about what data you're sharing with whom, so that if one of your third-party data processors did have a breach, you would be able to notify the ICO of that within the 72-hour time frame. Not all data breaches will require reporting, though. Those that will require reporting are just those which are likely to result in a risk to the rights and freedoms of individuals. For example, breaches which could result in individual discrimination, damage to reputation, financial loss, loss of confidentiality, or any other significant economic or social disadvantage. Where a breach is likely to result in a high risk to the rights and freedoms of individuals, you will also have to notify those concerned directly. IFAC will be assisting without this, though, and will be there to help you with putting these procedures in place. Okay, so having considered what the GDPR is, we will now move on to thinking about how to prepare for it. I will just go through a few frequently asked questions. So first of all, what if we haven't done anything yet? Is it too late? Okay, so no, it's not. You do have until the 25th of May of this year, so there is still time, but as you can probably see by now, it is quite a lengthy process, so it's not worth delaying. It is worth starting as soon as you can. Secondly, if you haven't completed by the 25th of May, then yes, you would be in breach, because at the end of the day, this is a European law which will be directly applicable to English law. So if you haven't completed the GDPR preparations by the 25th of May, you would be breaking an English law. However, of course, any steps that you have taken towards becoming GDPR compliant would help to mitigate this. And if you start now, there's no reason that you should be in breach by the 25th of May. There's essentially no shortcuts, but becoming compliant with IFAC will make the process much more manageable and robust for firms. The benefits of audits and forms are being able to show that you've taken the necessary steps towards compliance and having that paper trail and evidence in place if anyone asks what you have done. It's just worth noting now too that potential fines for non-compliance with the GDPR are significantly higher than what they were under the Data Protection Act. Currently, under the Data Protection Act, the maximum fine you can face is £500,000, but that skyrockets under the GDPR to €20 million, or 4% of global turnover, whichever is highest. So, with such enormous fines in place for breaching GDPR, it's really not worth taking the risk. Okay, so IFAC have put together a checklist of the main tasks for firms to action before May 2018. We are here to assist you, and we do realise that becoming and remaining fully GDPR compliant will take a significant chunk of time. There's unfortunately no way of getting away from that, but IFAC can take the stress out of much of it and hopefully provide you with peace of mind. Okay, I am now going to look at the journey to GDPR compliance with IFAC. So this is the compliance package that IFAC are offering you. First of all, today we're on the first stage. That's increasing awareness. That's making sure that anybody in your firm involved with personal data, handling or processing personal data, is aware of GDPR and its impact and their responsibilities under GDPR. Okay, so that's really today's session, is just to increase awareness. The next step will be to consider whether it's necessary to appoint a data protection officer or who the responsible person within your firm is going to be. Whether that's one person or several people will just depend on the volume of personal data that you process and the particular circumstances of the firm. Every firm, though, will need to delegate at least some form of responsibility in this regard, whatever their size. The next step will be you using IFAQ's microsite to upload your client data and any other personal data onto the personal data inventory. This is an extremely easy process. There's two possible ways of doing it. You can either put all of your data into an Excel spreadsheet and then bulk upload onto the microsite, or you can go onto the microsite and you can upload clients one by one. This will also be set up to contain all future data. It will involve you putting in basic information about the client to identify them, and then answering a few GDPR-related questions to ensure that each data piece you're uploading is fully GDPR compliant. And if it's not, then looking at what necessary action needs to be taken. IFAQ will, of course, act as a helpline via phone or email throughout this process, and we can also arrange one-to-one video calls if you need any support at this stage. Next, IFAQ will provide a checklist of the required steps in assessing all third-party contracts with processors or joint controllers. And again, you will need to record this as part of the inventory process. And at this stage, IFAQ will complete an audit of the inventory so that you have the paper trail in place. Firms will then receive comprehensive online training covering privacy notices, consent forms, third-party contracts, data breaches, and individuals' rights. Following on from this, firms will need to go away and put policies in place for how these will apply within their firm. This again will all be checked and signed off by IFAQ. Of course, any individual issues that crop up will be dealt with by phone or in-site audit visits, and by the 25th of May, all firms should be fully GDPR compliant and will receive frame certificates for course completion. And at this stage, all firms should have a structure in place that they can use for ongoing compliance. Bespoke ongoing compliance and monitoring to ensure that firms remain GDPR compliant is a key element of IFAQ's package, and this will involve online compliance audits. It will also involve an IFAQ online seminar, which is a must for all employees of a firm which are involved with data. The online seminars will be updated on a regular basis so that you can show that you're aware, and you will also have the opportunity to sit online exams to evidence your knowledge. Again, this will be recorded for audit purposes, and it will be repeated at regular intervals. Okay, that is the end of today's presentation. Thank you for listening, and I hope that you now feel much more informed about the GDPR.